Hello, everyone, and welcome back to the Bravo Docket. Today, we're going to take a pop culture lawsuit and break it down for you by popular request. Really, what tipped me over the edge into thinking that we might need to cover this was meeting with Ronnie again and him asking if we were going to cover it. And I was like, do people care since there's been a verdict? But I think people do care. This was a really interesting trial. It was one of the few that was televised, or not one of the few, but, federal trials usually are not televised. So it was interesting that we could watch this state trial happen and that it involved a celebrity. So I think all eyes were on it, and we're happy to go through it and cover it. If you don't know the verdict, I won't spoil it for you yet. I think many people know what the outcome is, but we'll go into everything, the facts, the trial, your top questions that we received on our social media, and just anything else that we found interesting. It was a pretty interesting trial. There was some interesting lawyering going on, and we'll give our thoughts as we go through.
Yeah, I was really excited when you wanted to talk about this one, and you said Ronnie from Watch What Crappens was really interested in it, because I love trials. This is what I do. I'm a trial attorney. Ceci also does trials, so this is always fun to talk about.
Okay, so let's dive into it with who the people are in this lawsuit.
Yeah, I was curious. I honestly hadn't really followed much of anything about this trial until we started to get requests for it. So I tried to look up Dr. Terry Sanderson, who was the initial plaintiff in the case. According to his LinkedIn profile, he is a former optometrist who currently serves as a private practice consultant. He's 76 years old, and he was educated in optometry at Pacific University. Then he became a private optometrist in Soda Springs, Utah, and he is currently still based in or near Salt Lake City, at least according to his LinkedIn. And before his 2016 collision with Gwyneth Paltrow, he had been skiing for 30 years. According to Sanderson.
Yeah, and I think it's important to add that he did a lot of volunteer work, according to him, before the accident, because that comes up during the trial. Gwyneth Paltrow, for those who don't know, is a famous actress and owner of Goop. She was in popular movies like Shakespeare in Love. She was in Iron Man, a pretty mega celebrity. You want to give your summary on Gwyneth Paltrow?
Yes, I had some fun facts that I connected to the Bravo universe. Ceci and I are huge fans of Real Housewives of New York, and Countess Luann de Lesseps became a countess by marrying Alexandre de Lesseps, and he was a descendant of Ferdinand de Lesseps, the famous French diplomat and entrepreneur who built the Suez Canal and started the Panama Canal. Gwyneth Paltrow won her one and only Oscar for playing Viola de Lesseps in Shakespeare in Love, and it's believed that the Lesseps family in Shakespeare in Love was based upon the actual de Lesseps family that built the Suez Canal and that Luann eventually married into. So Viola de Lesseps, who is the character in Shakespeare in Love, was not a real person, but it's believed that that family was based on the actual de Lesseps family. Then also, I think Gwyneth is perhaps most famous, despite her Oscar, for being friends with Kelly Bensimon.
I don't know if she's most famous for being friends with Kelly Bensimon, or if her name has been mentioned by Kelly Bensimon as a friend of hers. I don't know if they're actually friends.
I was making a joke.
No, I know.
Yeah. So, as we all know from Scary Island, Kelly claims that Bethany attacked, quote, her friend Gwyneth in the press. Gwyneth was on Watch What Happens Live not too long ago and was forced to watch the Scary Island clip and share her thoughts.
And she was like, what in the world?
Yeah.
She did not. I don't think she's supported the testimony that Kelly Bensimon gave at Scary Island that they were friends.
No, she seemed honestly kind of confused on Watch What Happens Live. And then I couldn't help myself, and I had to look up some of the craziest things that have been on the Goop website. I found several references. It's not currently available, I looked, but to psychic vampire repellent spray. And that was one of the more reasonably priced items on the Goop website when it was there at $30. And the spray, manufactured by Paper Crane Apothecary, reportedly a mix of aromatherapeutic oils that have been reported to, quote, banish bad vibes and shield you from people who may be causing them. Ingredients include, quote, sonically tuned water and a blend of gem elixirs, including ruby, bloodstone, and black onyx. Also on the ingredient list, Reiki, sound waves, moonlight, and love. Maybe I should get some of that before my next jury trial.
Maybe. I mean, a lot of these things are what you put into it. They're all placebos, so.
I think sometimes everything is talking about the same thing because the placebo effect is very real.
Totally.
There's theories in quantum physics that would explain some of this stuff. And then there's people who say it's witchcraft. I think if it makes you happy and it's not hurting anyone, do it and enjoy it.
Go for it. Spray your good vibes spray.
There was also a toothpaste squeezer for 178 pounds, which would be well over $200 in American dollars. And it's a quote, clever chrome plated brass device. So they plated chrome over brass, which I also thought was unusual. Gwyneth was so fond of the toothpaste squeezer that she featured it on her Christmas gift guide in 2015. I kind of think Goop is like Sky Mall for really rich people. And then I had to include one more thing, and then we'll get back to the trial, because I was really curious to see what you thought of this. I think it's adorable. It is a $34,000 bubble gum jungle gym featuring gold-plated details in lacquered wood. And it is by far the cutest jungle gym I've ever seen in my life.
It's for adults?
I think it's for children, but it's so cute. I just love the aesthetic of it. Do I have children? No.
Yeah, I mean, people roast Goop all the time, but it's clearly for a certain demographic of people who can afford this stuff and who have everything, you know? So
yeah,
if they need to buy something for someone and people likely don't have a toothpaste squeezer, why not? You know, why not go to the Goop website and find something as a gift for someone? I will say they have like good recommendations for workout clothing and stuff that I've gone on their website for, and some really good recipes. I kind of enjoy their YouTube videos where they show how to cook really healthy recipes. People give Goop a lot of crap, but there is some good stuff on there, and I understand it's uncomfortable to see a $34,000 play gym, but people are buying it.
Google it, you guys.
We're not, but
Google
it's so
$34,000 bubble gum gym. It is the cutest thing. Again, I don't have $34,000 to blow on this or children that would use it, but it's so cute. I admittedly loved Sky Mall, and I like Goop because it's Sky Mall for really rich people. So it's also things I wouldn't buy, but I like looking at them.
Yeah. I actually miss Sky Mall. I think they should bring it back, like
Me
an app or
too.
something, or like a channel on the airplane.
I loved Sky Mall. The thing is, I'm actually kind of glad we don't have it now. Now I'm an adult with adult money and would probably end up buying things on the plane after a vodka cranberry.
Yeah. Except I think Sky Mall now are people's Amazon storefronts that we get advertised on TikTok constantly. So ours is good. Our personal one that we have for the podcast is really good.
Yeah.
But I'm just saying, I feel like Sky Mall is now Amazon storefronts.
Oh, yeah. I got a new thing I need to add on there. I got it for Warlock and Moon, my cats, but it's this cat donut thing that they get into and they can also sit on top of, and they loved it immediately. I need to put that on there. All right. Enough with cats and Goop.
Yeah, getting to the lawsuit. So Sanderson, he's the one who initially filed the lawsuit on January 29, 2019. And he alleges that Gwyneth Paltrow was skiing out of control and hit him from behind, knocking him down and landing on top of him. Afterwards, he alleges that Gwyneth got up, skied away, did not offer any help. He also initially included the resort where they were skiing and then the ski instructor that Gwyneth Paltrow was skiing with, and said that no one did anything about his injuries either. And he initially sought $3.1 million, but then amended it to $300,000. And we'll look at his complaint to go into more on his damages. But he does claim that he suffered some brain damage that affected his personality and his quality of life after this collision.
Yes. And just to remind everyone, this is civil as opposed to criminal. So the burden of proof is different. The burden of proof is preponderance of the evidence, which just means more likely than not. In a criminal case, the burden of proof is beyond a reasonable doubt. So here, the burden of proof, like in all civil cases, is quite a bit lower than the criminal burden of proof.
It's also in Utah State Court.
So here's more details on his complaints. Paragraph 21. Gwyneth Paltrow knew it was wrong to ski out of control, too fast for her ability, and distracted, but she did it anyway. Paragraph 22. Gwyneth Paltrow knew that a downhill skier almost always has the right of way, and Sanderson was downhill from Paltrow when she approached Sanderson. Paragraph 23. Gwyneth Paltrow knew it was wrong to slam into Sanderson's back, knocking him down, landing on top of him, knocking him out, and then leave, which is just how it's written, the scene of the ski crash she caused, but she did it anyway. This is an unusually kind of worded complaint, I feel like, just the way it's written.
And then he alleges as a direct and proximate result of the negligence, by initially, like I said, he had sued the resort and then the instructors and other employees working there, but then he dropped them in his amended complaint and just was suing against Gwyneth Paltrow. He said because of their negligence, he suffered physical and mental injuries, including permanent traumatic brain injury, 4 broken ribs, pain, suffering, loss of enjoyment of life, emotional distress, and disfigurement. And plaintiff will continue to suffer injuries and damages in the future due to the negligence of defendants. He incurred medical expenses and additional life care expenses due to injuries caused by defendants and will continue to incur additional expenses. And then his causes of action were negligence against Gwyneth and then also negligent infliction of emotional distress. Before we jump into the trial, Gwyneth Paltrow also countersued for $1, basically reversing everything that Sanderson alleged in his complaint and saying, no, actually, Sanderson skied into me. I was downhill from him and he skied into me. It was kind of like a he said, she said sort of a trial. So it was really a case of conflicting testimony with no actual evidence, like hard evidence. So that's why it was such an interesting trial to watch.
And it was really smart. And we'll talk about this more later when we get to the listener questions, but we'll talk about that more later. So this trial lasted 8 days total. And we're just going to briefly go through some of the kind of highlights from some of the testimony before we get to your questions. As this trial was going on, what was one of the things that you sort of found the most interesting, like in the little clips or whatever?
I think what the media kind of globbed onto was Gwyneth Paltrow's behavior at trial and her outfits and the fashions she was wearing. I think people have, and me included, an odd fascination with courtroom outfits and what people are going to wear. I remember that was something I was looking forward to with Jen Shah's trial. I think Gwyneth chose some pretty good outfits. They were very neutral. Of course, some were like Prada, some were the Row, crazy expensive sweaters and shoes and such. There was also a lot of attention to what kind of planners and journals she was carrying, and people looked it up and it was like a $250 journal that she was carrying, or the fact that she was sipping bone broth during the trial, or the fact that her and one of her attorneys offered the bailiff treats. And the judge was like, you can't do that. Very soccer mom of Gwyneth to offer everyone treats. But I think that was pretty interesting to pay attention to. That caught my attention initially. But then, I mean, I can speak to it more when we get to her cross-examination, because there were some things in there that made me snicker. Yeah, that was my initial, what caught my eye when I was watching or paying attention to the media.
The first day of trial, obviously, opens with opening statements. And as Ceci already mentioned, Gwyneth brought a counterclaim. Anderson's attorney, Lawrence Buehler, said in his opening statement that Paltrow was not looking in front of her as she was skiing downhill and instead looking at her children. He said the sole eyewitness to the crash was Craig Ramone, an acquaintance of Sanderson's. Ramone, who was in the group with Sanderson, later testified that he was skiing down the run when he heard her scream and looked over and saw the skier slam into the back of Terry. He said that Paltrow hit Sanderson hard and bounced off of him. Ramone said once he reached them, Paltrow got up and did not answer whether or not she was okay. So there's supposedly some witnesses, but there's also conflicting statements about whether or not people actually did witness the incident. And then Paltrow's attorney, Stephen Owens, disputed the claims and said in his opening statement that Sanderson caused the collision when he moved to avoid another skier and interlocked his skis with Paltrow's. Owen said that after the collision, Sanderson apologized to Paltrow and told others that he wasn't sure what happened, and then that Paltrow stayed on the scene until ski patrol came and asked Sanderson if he was okay. I will note that I think both sides agreed that Sanderson had some broken ribs, but the other injuries were very much disputed, and then also the amount of pain and suffering was disputed, and then, of course, how the accident was caused. Those were all issues of fact for the jury. Do you want to talk about some of the things that Paltrow's attorneys brought up to counter some of Sanderson's claims?
Yeah, so they tried to bring up that he had health issues before the accident, like dementia and partial blindness. They tried to represent that he was an angry, aging man who continued to travel internationally after the collision. There were photos when they tried to provide evidence of his travels post-collision to show that he was living a fulfilling life and unaffected by any supposed injury. They also called the trial an attempt to exploit Gwyneth Paltrow's fame and suggested she's vulnerable to unfair, frivolous lawsuits. And this email where I think he sent it to his children with the subject line, "I'm famous," and they brought that up to question his motive for bringing the lawsuit.
Day 2 of the trial was a lot of testimony from medical experts trying to persuade jurors that the collision caused a lot of irreparable damages to Sanderson. So they had a radiologist who said that brain images suggested that Sanderson's head trauma was likely caused by a skier crashing into him to support his claims that he was hit by Paltrow. And then he said that the lasting effects on Sanderson's overall health were consistent with the severity of a collision, and that, quote, "the rib fractures certainly corroborate that there was enough force to cause a head injury." And then a neuropsychologist called Sanderson's post-crash trajectory an acute rapid downturn. One side hires an expert to say one thing, and the other side hires another expert to say another thing, and then it's kind of dueling experts. So it really comes down to the jury using their common sense to decide what is the accurate information here and what is more believable. So day 3, I think, is when the GoPro footage came out that Ceci was talking about. Do you want to talk about that?
Yeah, so what happened was that there was a meetup page or a forum. I think it's like those meetups where groups involved in a shared interest can plan events at which they can meet up and enjoy their shared interests. And so I think there was like a forum, and supposedly there was a link to GoPro footage in that forum discussion. And so Sanderson's daughter took the stand and they questioned her as to where that GoPro footage was. And her testimony was, "I don't know where the link went to. It's somewhere in the cybersphere." I want to pause. And this is something that happened outside of the trial. So people's eyes were on this. There were a lot of internet sleuths watching this. And when people saw that link, the world was like, where does the link go to? Why has no one figured out where this link goes to? And there's an individual, let me get his name, Michael Fletcher. Michael Fletcher was watching this trial and he's like, where does this link go to? Why doesn't anyone know? Neither side knows where the link goes to. Why hasn't anyone investigated this? So he created his own account for this forum, clicked and he couldn't figure out where the link went to, but then ended up uncovering messages in the forum where Sanderson acknowledged that he knew it was Gwyneth Paltrow that he had a collision with. And I think that's important because throughout the trial, he tried to say he had no idea who the woman was, and these messages proved otherwise. And this individual, not even involved in the trial, sent him to the attorneys and was like, why didn't you guys find this? Anyway, I don't think it's like super critical to the facts in the case. It's just, it sheds a little bit of doubt on Sanderson's side if these are authentic and verifiable pieces of evidence and like messages. But just very interesting. It is so important as an attorney to mine the corners of the earth, and in this case, the corners of the internet, to find evidence. I think maybe sometimes attorneys get hung up on creating accounts and the ethics of that. You can never add someone on Facebook in discovery. Like you can add a witness on LinkedIn or anything to go dig on their LinkedIn. That is beyond the code of ethics. But you can create an account to go find evidence. And I'm just kind of shocked that no one did that and that this random viewer did it.
Yeah, that's interesting.
Yeah, so this is her testimony. She said, I've never seen GoPro video and I don't know that it does exist. I believe there was GoPro video at the time and that's why I said that. And I think she was trying to insinuate like everyone who skis now has GoPros, but I just don't know how believable that is. Why would you say that there's GoPro footage and then just be like, oh, I just kind of guessed that there might be? I think there was footage and maybe it wasn't as favorable as they thought it might be.
In a jury trial, that's really bad. If ostensibly there was some type of video evidence or something that would be definitive and then it disappears, typically jurors are going to not look favorably upon the party that had control or knowledge of that evidence if it is then gone, especially if it's brought up in trial.
Yeah. Anyway, so a lot of her testimony, this is the daughter's, was to talk about how his behavior changed after the accident. I think they were trying to get at, through her, that Sanderson had anger issues before the collision occurred and that he was a little bit snappy. She definitely said he was snappier after the accident and had issues with his memory. But I think before the accident, there were instances where he suffered from behavior issues as well.
I know he put that at issue because he claimed mental injuries and emotional damages. So his demeanor and behaviors prior to the incident would be relevant to determining how those changed and how they didn't change. So day 4, I think, is when Paltrow took the stand and she claimed that Sanderson collided into her. She explained she was on a ski trip with her children, Apple and Moses, and her then boyfriend, Brad Falchuk, who she is currently married to, and his children. She said on cross-examination that she was an intermediate skier and she was on a green run when she was allegedly hit in the back by another skier, i.e. Sanderson. Paltrow said, quote, 2 skis came between my skis, forcing my legs apart. And then there was a body pressing against me and there was a very strange grunting noise. My brain was trying to make sense of what was happening. I thought, is this a practical joke? Is someone doing something perverted? This is really strange. And I think one of the things that I noticed from the trial was the kind of cringy exchange between Sanderson's lawyer when she asked Paltrow how tall she was. Do you want to be Gwyneth Paltrow? And I'll ask you a question.
Sure.
So how tall are you?
I'm just under 5'10".
Okay, I am so jealous.
I think I'm shrinking, though.
You and me both. I have to wear 4-inch heels just to make it to 5'5", so...
They're very nice.
Oh, thank you. That was very good, Gwyneth Paltrow.
Yeah, well, I watched it, so I know exactly how she sounded during that exchange. That was one of the many cringy exchanges during this cross-examination. So after all this, then she mentions Sanderson's height, and she's like, oh, but you're also a small woman. And then she's like, actually, you're not that small. You're 5'10". Just like, it was very cringy. And then there was another instance where they were talking about what she was wearing, and the cross-examining attorney was like, I'm sure it was the nicest outfit on the slopes. And it's like, I understand trying to butter up a witness and get them on your side and feeling comfortable, but it seemed so kiss-ass and cringy. Like,
yeah,
girl.
I have a lot of thoughts about that I'm going to talk about later in response to some listener questions. I don't want to criticize the attorney. I do know that she did not take Paltrow's deposition, so she didn't kind of have a baseline. And I can't imagine the amount of pressure that you're under when the entire world is watching you do a cross-examination. There are times where I think more of that type of familiar or non-threatening cross-examination can work, but I agree with Ceci that in this instance it didn't. But there is a time and a place for it. I think it didn't come off the way she was hoping it would in this trial.
Yeah, she also tried to get Gwyneth to reenact it off the stand. She was like, okay, stand up, come down here. Stand up, come down here.
Yeah.
And Gwyneth's counsel was like, objection, you're not, this isn't a question.
I mean, there are times where that's appropriate and where it does work. If someone is claiming that, someone hit them a certain way, you can ask them to demonstrate for the jury, but typically you get approval for that beforehand. You file a motion saying that you would like to do a demonstration.
With like little cars, not with the counsel's body and the witness's body.
The attorney cross-examining Gwyneth Paltrow was wanting to get behind Gwyneth Paltrow in front of the jury. That's risky on a lot of levels, even if the judge had allowed it. Something like that can go so wrong. She's cross-examining, so she wouldn't have gotten to rehearse that. That's more like something maybe you would try with your own witness that's going to be friendly to you.
You think Gwyneth is going to like stand behind you to show how she... Yeah, Gwyneth says she didn't hit him. So why would she be willing to stand behind the attorney to play out how she didn't hit him?
Yeah, and then it's also hard to take down for the record. You have to kind of describe it as it's happening.
It didn't work.
Yeah. No, and I agree it didn't work. I'm saying there are times, but this was not, I agree with you 100%. This was not. Yeah. And the judge didn't allow, thank goodness.
It would have been easier if she had like a diagram on a whiteboard or something.
Dolls.
Mm-hmm.
Yeah.
And I think they had an expert that did it. So.
Well, obviously Gwyneth had a lot more resources, even though this man is a doctor and does not appear to be poor or even middle class. He seems very upper middle class, but Gwyneth had actual graphics and animations made by her experts.
But they could have just done like stick figures.
Yeah. Sometimes very simple trial demonstrations or demonstrative exhibits are some of the best. Can be very effective when you keep things simple. But jurors don't have any control over how long they're sitting there. They have to listen to everything. There's a lot of sidebars typically in a contentious trial like this. So anything you can do to keep them entertained is good. Having those animations was probably very compelling to the jurors in this case.
Yeah. Before we move on from Gwyneth's testimony, I do want to note that Gwyneth did clarify that this wasn't a sexual assault lawsuit because they had her clarify that on the stand, because I think when she initially got hit from behind, she said she heard grunting and thought there was something perverted happening, but then clarified, like, yeah, this is not a sexual assault lawsuit. That's just how she initially felt. She felt someone heavy on top of her and was able to tell it was a man and got freaked out.
Yeah. And I think that's another good reason why the judge didn't allow a physical reenactment of it. I think day 5 is when Sanderson took the stand, and there were lots of things about him on the stand that didn't work in his favor. For example, comparing Gwyneth Paltrow to Jeffrey Epstein. I don't think that was good. Yeah, I just watched his testimony, and they were trying to ask him why he brought this lawsuit and how it's affected his life. And then he's like, and the celebrity, and then you have molesters out there, and it's like, whoa, what? Where are you going with that one? Oh my God.
And then I paused and I was, has Gwyneth Paltrow been accused of molesting any? Like, I honestly stopped and I was like, what is he talking about?
Yeah. Yeah. And this is again where, and we mentioned how they brought this up in the opening. And then when you bring something up in your opening statement, it's really important, if you promise the jury you're going to say something, that you follow through with that. On his cross-examination, Gwyneth's attorney did a slide presentation of his social media posts since the accident, showing him leading an active and happy lifestyle of vacation after vacation, which clearly, if you're sitting on the jury, that is going to contradict extended pain and suffering if you're on vacation in Switzerland and appearing to have a great time. That's not good evidence for Sanderson in this case. And for the most part, this is a wealthy county, but not every juror on there is going to be vacationing in Switzerland or France. He almost seemed just as unrelatable as Gwyneth Paltrow for some of these things.
Yeah, there was a lot of time spent on this, and there were a lot of trips, and there were a lot of activities like him hiking. He was like, isn't it true that this is you hiking a mountain range in a foreign country? He was like, yeah. And then I think part of his damages at one point was that he lost out on the normal things that he enjoyed doing with his friends, like wine tastings. And so this is just in such stark contrast to that. It's like, you seem to be living a very fulfilling life. However, he explained it when he got examined by his own attorney and said, I was just trying to live my life and break through the injuries I had sustained and my brain issues by going out and traveling. I thought it would help.
Yeah, it's kind of like, oh, I didn't feel good and I thought it would help to go on this expensive vacation many times all over the world. It doesn't make you very relatable to a jury. So
he did also testify, just to add some more from his side, about how he had to stop volunteering. It involved a lot of walking. And he said at one point he got lost and was too stubborn to like look his way back up on a map. But after that, he was like, I've lost my ability to direct myself on this path that I've taken before, and stopped volunteering. On day 6, Gwyneth Paltrow's children, Apple and Moses, testified via deposition, and they testified that they didn't see the crash occur, but Apple at least remembers Gwyneth after saying, man, up there, back there, like this guy skied into my back. I can't ski for the rest of the day. I'm going to take the day off, which she said was sort of unusual for her to not continue skiing. And that was like a big, people were talking a lot about during Gwyneth's cross-examination, how the attorney was like, did you suffer damages in this?
Oh, yeah.
Like, was it very expensive? And she was like, well, I lost half a day of skiing. And yeah, she did.
I mean, it's like $7,000 a day. So
yeah, it's expensive.
It was really expensive. If she was a normal person and not Gwyneth Paltrow and had saved up money for that vacation, losing half a day of skiing when it's $7,000 a day would be crazy.
Yeah. The ski instructors also testified that same day and said that they never wrote a report because there were no injuries, but they would have had there been injuries at the scene. And they remember talking to Sanderson and making sure he was okay. They also went through the responsibility code for skiers. It came up a lot during this trial because there is one. There's a certain decorum that people abide by when they're skiing. I imagine it's similar to when you go out sailing. It's like what boat has the right of way and which one has to turn if they see the other boat. So the responsibility code, they spoke about it at length at trial. It's always stay in control. You must be able to stop or avoid people or objects. That's why I don't ski, because I do not abide by number one.
Yeah, we already know about you at a trampoline park.
I'm like not coordinated. Even though I was a dancer for many years, I am not coordinated.
I don't believe her, by the way. I've seen her pictures of her and her awards for dancing. So I don't believe that she's not coordinated. I'm just
on a stage, not on moving skis. People ahead or downhill of you have the right of way. You must avoid them. Stop only where you are visible from above and do not restrict traffic. Look uphill and avoid others before starting downhill or entering a trail. You must prevent runaway equipment. That's another one that seems hard. Read and obey all signs, warnings, and hazard markings. Keep off closed trails and out of closed areas. You must know how and be able to load, ride, and unload lifts. That's another scary one.
Yeah, getting off the lift on a snowboard is terrifying.
Do not use lifts or terrain when impaired by alcohol or drugs. If you are involved in a collision or incident, share your contact information with each other and a ski area employee.
I don't know much about skiing. I've only snowboarded a couple times. I'm much more familiar with things like wakeboarding and surfing because I grew up in Florida. When I was watching the trial and I was looking at the YouTube comments, which I admit are not necessarily the most credible things, but there were a lot of people who claimed to be avid skiers who said, if I sued somebody every time someone ran into me on the ski slope, I would be suing 20 people. Incidents where people accidentally run into each other are very common. So I'd be interested in hearing from the skiers out there if that's true.
And then this is the same day that they call the engineering expert, I think, like you mentioned, on the mechanics of how the collision could have occurred.
Which I generally think those are pretty fun to watch when you've got a really good biomechanical engineer who can talk about the velocity and forces involved. The closing arguments were really interesting. I really enjoy watching opening statements and closing arguments, seeing how people use their own personalities and strengths in their opening and closing statements in order to make it the most effective for their client. I don't really like criticizing other attorneys, but I will say that the closing argument for Sanderson was, it's not, there were choices made that I wouldn't have made.
So what did you not agree with the?
Well, I do think it's very important to be streamlined in your presentation of evidence and in your closing. Again, the jury has no control over how long they're sitting there. It's a privilege to have a jury hear your case. And what could be perceived as rambling digressions are not great. I don't see any reason to mention the Magna Carta, pilgrims, or the Latin definition of the word verdict in a closing. And there was an extended cow milking anecdote. And this is a shortened version. Sanderson's attorney was saying, I was in the legislature with a guy named Glenn Brown. He invited me up to his farm, young lawyer, showing me how to milk cows, never done it. Got up there and he showed me around his barn. It was really sophisticated. But when you think about why Terry never came home, and this is metaphorically speaking from his ski trip accident, think about this story. He put a little stool out there for me. I sat down in my jeans and tried to milk the cow by hand. It's very hard to do. I was able to squeeze out a little bit of milk. I said, how do you all do this? And he showed me this very sophisticated machine that milks cows automatically. He says, without this, Bob, I'd never make it. That milking mechanism was the executive function for Glenn Brown's farm. Now, one of Terry's saddest problems is his loss of executive function. So he was trying, I think, to relate the loss of executive function or mental capacity by Sanderson from being hit allegedly by Gwyneth Paltrow on a ski slope to milking a cow by hand versus milking a cow with a expensive milking machine. That's what I'm talking about when I'm saying I don't think that this type of anecdote plus analogy really works or is effective.
Also, if you break down the analogy, it doesn't work because is he saying if you can't use your hands to milk the cow, there's another way. Which in that case, it doesn't help Sanderson at all. Because then you're saying, well, if you can't do your job, there's another way. And isn't he still employed?
Again, that was...
It's so long, too.
Yeah, I don't know how that sounded in his head.
Did the cow run into Gwyneth Paltrow, too?
Exactly.
What are you talking about?
It's like if you're going to do a digression or misdirect the jury's attention to something else, it should be something really interesting that makes your client look really good, or I don't know. I think he was trying to actually make an analogy and it just didn't land, and it was also really confusing.
Yeah.
So that was one of the things that really struck me from the trial. Also, Sanderson was apparently, to a lot of people, not particularly likable. I didn't find him to have a particularly likable quality on the stand. His own lawyer said, quote, "When people get to know Sanderson after a while, they don't want to deal with anymore. These are real injuries. Your personality changes permanently. You lose everybody who knows you. You lose everybody. Your family, they'll put up with you, and maybe the lawyers. But really, they're just putting up with you."
What?
And then so if you don't even like your own client, there would have been a better way to say that. I think he was trying to say, my client has had personality changes as a result of these devastating injuries. And these personality changes can make him difficult to deal with. And that is something that he suffers from, or something. I don't know. But that just was basically... It's just not great.
Just roasting him.
Yeah. When your own attorney is trying to explain that you're unlikable, that's not great.
And then the other guy?
Oh, yeah. Paltrow's attorney during closing, I think, had some very effective statements. Quote, "He doesn't tell his doctors he's flying all over the world, that he's biking, that he's the poster boy for fitness at age 75. He's posting online every darn thing. This isn't me sending out a private investigator and trying to find pictures. All I have to do is type Terry Sanderson, and oh my God, the man is Mr. Activity." That was much better. Example of a much better type of thing to say in closing. It's to the point. He's still adding some color to it. He's saying it from the perspective of somebody who wants someone to vote a certain way when they go back to the jury room. But it makes the point, and it's very clear the point he's making.
Yeah, he didn't go into... He's running up hills like cows on the farm. Yeah. Well, the verdict came back and the jurors ruled that plaintiff Terry Sanderson was 100% responsible for the crash, despite his claims that Paltrow crashed into him on the slopes. So Paltrow received her $1 award for the damages.
It's always interesting how long a jury deliberates. And here the verdict came back after only 3 hours. So if you haven't been on a jury, one of the first things that you have to do when you go back in the jury room is elect a lead juror. And that's the person that actually reads out the verdict and writes everything down on the form typically. In some states, it's called a jury foreperson. So that usually takes at least 20 minutes, sometimes a half an hour. And then the jurors typically go through the jury instructions as it's laid out. 3 hours is pretty quick after closing arguments wrapped. That means that one side did a really good job if it's 3 hours or less. I think this jury verdict makes a lot of sense to me from the evidence that I saw. What do you think?
I agree. I think it makes sense. It was a hard one because it's like totally conflicting evidence or testimony, claims, everything. Everything is totally directly in conflict. But yeah, I think they reached the right decision. So let's get to some listener questions. We got a lot. And we thank you for your questions.
Yeah, you guys had good questions.
Mm-hmm. So the first, how common is it to sue another for a skiing injury? Are we all at risk of these types of suits when we hit the slopes?
Personal injury suits are very common. They're more common in states that don't have a lot of tort reform. So if you're in a state that doesn't cap damages for pain and suffering and provides more incentive to file lawsuits, then you're more at risk when you're in that state for something going on. I wouldn't walk around being afraid of one. Just use ordinary care and common sense, and you're probably going to be fine.
Yeah. And then the ask, like, are we all at risk? Yeah. I mean, if someone sustains life-threatening injuries following being hit in a crash, I would assume it's probably reasonable to expect a lawsuit for the injuries that were caused. So I don't think it's totally unreasonable.
If I have a condition that makes me prone to skiing or other accidents like bad vision, can I be held liable in a case like this?
Yeah, I think it depends. So if you're the aggravator and you cause the accident because of your bad vision, you're pretty much screwed in a case like this. I remember learning about this in law school. If you drive after you had a stroke and know that you're prone to strokes, and then you get into a car accident without taking proper care, you're screwed. I think it differs if someone else causes the accident. So if someone runs into you and you're partially to blame, then there's an analysis that goes in to see how much comparative fault there is. So how much of the accident was caused because you couldn't see versus the person running into you. You have more risk when you know you have a condition that could put you in harm's way or that could cause harm to others.
If a doctor has told you that you are likely to have a stroke or pass out, or maybe you're likely to have fainting spells and that you shouldn't drive, and then you drive, then you were on notice that you had those issues. Now, if you've never had a stroke before, you've never fainted before, you had no reason to believe that you might have one of those conditions and you get in a car and drive and you faint, then you didn't have any notice that that might happen. So that's different.
But yeah, if you're going out skiing and you know you need your contact lenses and you didn't put on your contact lenses, you get into an accident.
Yeah, exactly.
You're screwed.
Yeah. Or if you take medication that says do not drive or operate heavy machinery on this medication, and then you drive, even if the accident wasn't totally your fault, if that comes out in court, that's going to look bad. And
Real
you're
bad.
probably, really bad.
All right. So something that came up during Gwyneth's testimony or when she was being cross-examined was about Taylor Swift's $1 lawsuit. And they're like, why did you countersue for $1? So for those who don't know, Taylor Swift was the first to countersue for $1. And it all happened in an instance where in 2013, she was having a meet and greet backstage. And she posed with a man named David Mueller, who was a radio DJ, and his girlfriend for a photograph. Taylor alleged while they were posing, he reached up her skirt and squeezed her butt. Taylor immediately told her manager and her mom, and he was escorted out from the concert venue. Afterwards, his radio station did an investigation, and he was terminated from the station. In 2015, he sued Taylor for defamation, claiming that he didn't sexually assault her. His lawsuit said, the contention that Mr. Mueller lifted up Miss Swift's skirt and grabbed her bottom while standing with his girlfriend in front of Miss Swift's photographer and Miss Swift's highly trained security personnel during a company-sponsored VIP backstage meet and greet is nonsense, particularly given that Miss Swift's skirt is in place and is not being lifted by Mr. Mueller's hand in the photograph. And I included a picture of the photograph in our outline. This was actually under seal. Somehow TMZ got a copy of it, so.
It does look like his hand is in a spot where it should not be on Taylor Swift.
Very low.
Yeah, there's no reason for his hand to be there ever. So even if it's not up her skirt, which you can't see whether or not the back of her skirt is lifted, and it also looks like she is leaning away from him and towards the woman in the photograph and smiling politely. I don't like, even just looking at this photograph, I don't like it.
So he sought approximately $3 million in lost income. He acknowledged that Swift had been sexually assaulted, but blamed someone else. He blamed another radio employee named Eddie Haskell, claiming it was a case of mistaken identity on behalf of Swift and her team. Taylor filed a countersuit for battery and assault, so it's a civil case. In the suit, she expressed that she was completely aware of who had assaulted her, naming Mueller as the individual who deliberately groped her buttock inappropriately and without her permission. She also pointed out in her countersuit that he had actually been dismissed twice before from radio positions. She demanded a jury trial, but said she would donate any money won from the trial to charity organizations that protect women from sexual assault and other violent acts. The case went to trial. Taylor's mom and bodyguard testified, as well as the photographer who snapped the photo. Taylor testified that she felt his hand there for a long time. She mentioned she was super monotone with him and his girlfriend after, sort of like stern, like bye. His ex-girlfriend also testified, so the one in the photo with him, it's an ex-girlfriend now, that it was a really fast photo and she didn't really take note of where his hand was. The judge ended up dismissing Mueller's case for insufficient evidence before it went to the jury. So in a trial, if the prosecution finishes presenting their case and the judge is like, you haven't met your burden of proof, there's no evidence here, the judge can just dismiss it before it goes to a verdict. So it was only Taylor Swift's counterclaim that went to the jury for a verdict. And the jury ruled that Mueller had assaulted Swift at their meet and greet and awarded her $1.
That's fascinating. But what's the Gwyneth tie-in?
Yeah, so they just kept asking her questions like, are you only countersuing because you knew Taylor Swift did it? So they kept asking her, are you friends with Taylor Swift? Are your kids friends with Taylor Swift? And she was like, we're not close. I didn't get the idea from her. But also, like, who cares? Who cares where she got the idea from? But they, like, just kept going in on the Taylor Swift thing. Like, didn't you get the idea from Taylor?
I feel like that's not a good strategy at all. Also, Taylor Swift has a lot of fans. More likely than not, there is a Swiftie on the jury. Even if she did get the idea from, like, how is that relevant? I'm surprised the judge let that line of questioning in.
I was surprised with a lot.
Yeah.
In the trial. I would have been objecting my butt off. But yeah, I mean, Gwyneth is within her right to countersue if she has claims. So who cares where she got the idea to do $1? I think they were just trying to be like the symbolic $1. You think you're so da-da-da.
I mean, sometimes when the other side is doing something like that, you're like, I could object and it would probably get sustained. But I think the jury's hating this.
Yeah,
and they're digging themselves a hole.
Right.
I'm kind of wondering if that's what the calculation was to not objecting on that.
Probably. Why did it take so long to go to trial?
So Sanderson said it took him 3 years to file the suit because his legal team could not come to a resolution after meeting with Paltrow and her attorney. I'm assuming that they sent multiple demand letters and Paltrow kept saying no. And then finally, the statute of limitations was about to run and then they had to file the lawsuit. Another question, why was this case brought to trial? It seems like a waste of the court's time. If part of the question was, why didn't Gwyneth Paltrow just pay this guy? First of all, I think he was originally asking for a ton of money. And if I was Gwyneth Paltrow and I didn't cause the accident, I wouldn't let someone extort me for money, even if I could just easily pay it. I think that's completely reasonable. The right to a jury trial under federal law is protected by the 6th and 7th Amendment. The 6th Amendment states that in all criminal prosecutions, the accused criminal has the right to a trial by an impartial jury of the state and district in which the individual allegedly committed a crime. Likewise, the 7th Amendment states that for suits in common law, if the value in controversy shall exceed $20, the right to a trial by jury shall be preserved. States aren't required to guarantee civil trials, but most states have the right to a civil trial to some degree in their state constitutions. And I'm just going to get on my soapbox here because I think this is one of the things that no matter what your political affiliation is, I think the right to a jury trial in civil and criminal cases is extremely important. And we are one of the few countries that gives its citizens the right to use their common sense to decide facts. It's part of the reason why I'm an attorney. It's part of the reason why I believe in our jury system. And it also really helps keep the law in a sphere where ordinary people can understand it. Because when you have the right to a jury trial, you have to be able to explain the law in plain terms to non-lawyers. And I think that's so important for our justice system in both civil and criminal, because it keeps the law from becoming too esoteric and it keeps it within the sphere of what normal people can understand. And I think that's incredibly important. So that's my soapbox for that.
All right. So then how are attorneys' fees calculated? Is there a cap? In some countries, not the United States, the loser in every case has to pay the winning side's attorney's fees. In the U.S., one way to get fees is if there's a fee shifting provision in a statute. So if you're bringing a claim as part of a statute, so there's consumer protection statutes that let you get attorney's fees, civil rights statutes, especially those intended to prevent discrimination, environmental protection statutes, and others. There is attorney's fee awards in some of the work I do for trademark infringement under the Lanham Act. But to be awarded attorney's fees, if you are able to get them after you win because you sued under one of the statutes that allows you to get attorney's fees, you have to prove the fees that you're seeking and that they're reasonable. Most courts actually don't give the amount spent and billed dollar for dollar. Many courts use this fancy little calculation called the lodestar method, which multiplies reasonable expected billable hours by a reasonable hourly rate. And the court considers the attorney's experience and skill to determine what an attorney of similar expertise in the area might charge. Then there's a review of the hours, so they go through the bills and make sure that none of the work was duplicative or unreasonable. And so there's a lot of briefing that goes into calculating attorney's fees, you have to submit the totals. Usually it's like those who have more experience ask for more fees. It's sort of like a chart, and you kind of see like the more junior people charge less. And a lot of times you have to attach the bills and all of the entries. That's why we keep time. It's the most annoying part of the job. I hate it with passion. We have to keep track of everything we work on. But it's for instances like this. And I mean, of course, it's for the client to review the bills. But
yeah,
if you get attorney's fees, then your bills are going to be reviewed.
Yeah. And I have been awarded my attorney's fees when I have litigated a case successfully for clients. And I have to say that feels great when the other side has to pay you.
Yeah, we had to do that too. Or we were awarded attorney's fees as well. But there's so much that goes into preparing the motions to get the fees.
Yeah, it's a lot of work. So one of the next questions was, why didn't it get thrown out earlier? The question that's really being asked is, why did the judge allow this case to proceed? And the short answer is there was questions of fact. A jury is the one that decides the questions of fact. The judge decides what the law is. The judge says this is the law. The judge decides what the jury instructions are that tell the jurors how to decide the questions of fact. Like I said, when talking about the jury system, it's everyday, ordinary people who get to decide using their common sense and experience in life as to who was more credible and what the actual facts are. And here the jury decided that Gwyneth Paltrow was more credible and that she was not at fault for the incident and that Sanderson was.
Yeah, and I will note there are instances in a case when you can get it thrown out earlier, but if there's still a question of fact and it's not clear cut, even after seeing the evidence, it has to go forward to a jury.
Yep.
Who chooses what trials are televised?
No federal criminal trials are televised. Broadcasting and photographing criminal proceedings in federal courts is prohibited under the Federal Rules of Criminal Procedure. A few federal district courts and circuit courts allow recordings under certain limited circumstances. All 50 states allow cameras in the courtroom to varying degrees, but judges typically have a lot of discretion in the state courts. There's a lot of reasons for prohibiting cameras, and then there's a lot of reasons for letting the cameras in. Of course, I think all trials should be generally televised unless they involve minors or divorces or something sensitive. But I understand the arguments for and against. It can lead to a sideshow type environment if it's not managed well. And I think it can really stress out some of the witnesses quite a bit more that aren't used to testifying. It's already scary to testify in court. But then having a bunch of cameras and the public watching can make it more stressful. So it's typically up to the state judge's discretion.
Yeah, I think it's way more stressful. There was an issue in this trial where the camera was pointed just directly at Gwyneth Paltrow at the beginning. And her counsel had to be like, can you move that? This is not cool.
That's not cool.
Was there an obvious strategy behind plaintiff's attorney being so chummy with Paltrow?
So Ceci and I talked about this earlier, and we agree that a lot of the moments were maybe a little cringy and didn't come off quite the way she was hoping they would. But I just want to say that being a female trial attorney is difficult. If you raise your voice or show any type of emotion, we have a much greater risk of being seen as hysterical or emotional. If we're really tough and incisive, we can be seen as bitchy and unlikable. And then female attorneys are also penalized way more for our clothing and hair choices. Anyone familiar with the O.J. Simpson trial knows the uproar that occurred over Marcia Clark's hairstyle change during the trial. I think this attorney in the Paltrow case was trying to walk the line between being tough on cross-examination while also trying not to be seen as too combative. I mean, what do you think about that? I found some tweets, but then I also would actually rather read some of the comments on the YouTube video of her cross-examining Gwyneth Paltrow. But what do you think about that?
Women do have it harder. Like in the Depp trial, so many people were talking about his attorney, the female one, just everything she was doing. And I think it is harder. It made me cringe. The things she was doing here made me cringe. And it was probably strategic. It had to be. Everything we do is strategic in trial. It had to be. But I think there was a way to come across likable without being so cringe. It seemed like she was fangirling.
It did kind of seem like that. And I wish everybody would have some compassion. It would be very difficult to cross-examine someone like Gwyneth Paltrow under the best of circumstances. Typically, trial attorneys have a big home court advantage. We are used to being in court We are the ones that have more experience, typically, being in front of an audience and being watched. But here, there's an A-list celebrity that has won an Oscar for acting. You're not going to have that advantage with that person. That person is going to be better than you at keeping their composure with cameras on them. That attorney just did not have the experience with that type of exposure that, for example, Gwyneth Paltrow does and did.
Yeah. I mean, but to be fair, that attorney did really well examining her own witness. She came across very likable. And I understand it's a different situation, but I don't know. I wouldn't give her so much credit. I think it was strategic, but it landed so bad.
I am agreeing that it didn't land well, but I'm having some compassion for her as to why it didn't land well and how difficult that was. For example, this was a comment on the YouTube video. The female attorney is driving me nuts. She's so giddy about being a part of a celebrity case that she's behaving like a schoolgirl. And then here's another one. The attorney in the blue jacket is getting on my last nerve. I can't tell if she's starstruck or just acting foolish. None of these attorneys have impressed me. I'm stunned that GP's lead attorney is so incompetent, which I also think is another thing. People get used to seeing lawyers on TV shows, Law and Order, Suits, things like that. And they get used to attorneys being so polished and having everything scripted and everything being interesting because it has to be interesting. It's on a scripted TV show. And then when you see lawyers in real life, unfortunately, I think it's kind of a letdown because the trials are not as entertaining and the attorneys are not as polished as what you've seen on TV. We try to be.
I thought he was cringy too, honestly. I was like, what is this guy doing? Both of them. I was like,
yeah.
Oh God, both sides. But yeah, I mean, it is what it is.
I did a little intro cross-examination that I think would have been way more effective to do your own personal style. But I tend to be very precise. Also, the problem was when I was listening to her cross-examination of Gwyneth Paltrow, a lot of her questions weren't very tight. They gave wiggle room. They allowed for sort of an explanation as opposed to just a yes or no answer. I think it would have been really effective to point out the fact that she is a trained actor from the very beginning and just not appeared starstruck at all and just treated her like a normal everyday person.
Yeah, I don't get the benefit of leaning into her being a star. I didn't strategically understand it.
Okay, if you would be Gwyneth Paltrow. Miss Paltrow, good morning.
Good morning.
Miss Paltrow, you're a trained actor, correct?
Well, I did that much of my life. Today, I'm mostly a mom.
However, you would agree that you are a trained actor, yes?
Yes.
You can read and memorize scripts, correct?
Well, yes, movies and shows have scripts, and that's my job when acting.
Right. And in fact, you are so good at acting and so good at communicating in a believable way that you've received an Oscar, correct?
Yes, I have received an Oscar.
You've played parts where you've cried on screen?
Yes.
And you've played parts where you've been in love on screen?
Yes.
And you've spent decades mastering various acting techniques, correct? That's probably all I would have done, is just at the very beginning, point that out, and then move on to the facts and cross-examine.
Yeah, but I guess to answer the question, was it a strategy to act chummy? Yeah. Outlines are written months ahead of time. How you're going to present the case is really thought out. So, yeah, it was a strategy. I don't know what the purpose was, but it was a strategy. So, what about the strategy of countersuing for $1, like I spoke about earlier? Why did she do that?
I think that was really smart. It gave her the chance to go on offense and not just defense. Typically, when you're a defendant in a case and there's no counterclaim, the person bringing the lawsuit, the plaintiff, goes first. You go second, so the plaintiff gets to go first with their opening statement and then also with their closing argument. And then the plaintiff gets to present their witnesses first. Here, we saw witnesses for both sides showing up at different times during the trial. It gave Gwyneth's team a lot more options for how and when to present evidence. And then it also gave the jury a way to vote in favor of Gwyneth without having to award a bunch of money. I think it was a smart strategy. And I think it also set her up better for getting her attorney's fees. Ceci, if you were Gwyneth's lawyer, would you be happy with Gwyneth's performance on the stand?
Yeah, I think she got her facts across well. I think she got her story across well, you know. I mean, people dislike Gwyneth Paltrow. It just seems to be a thing. People really don't like her, so they're really harsh on how she gave her testimony, maybe coming across not super likable or just kind of cold and stoic, but I think she did well. I don't think we need to critique her on whether or not she was very bubbly and outgoing. I think she did well. She told her story. It was clear. It was concise. She stuck to it. There weren't a lot of inconsistencies. I think she performed well.
Sort of the context I read into that question was, would we have coached Gwyneth to be more down to earth or more like an everyday, ordinary person, to relate more to the jury members? And I actually think what she did was great, because this was, like Ceci said, a case that really is asking who is more credible. And if Gwyneth had showed up and tried to act like she wasn't this super wealthy, Oscar-winning A-list actress that has this website that's well known for selling products that are far out of the scope of something that most people can afford, I don't think she would have come off as believable. Here, I think she came off very much as herself. I think the way she behaved on the stand is probably very similar to how she behaves in real life. And even if the jury didn't find her particularly likable, I think they found her authentic and credible.
Well, also one of the things that that they were trying to bring out in this case is that he only brought it for fame. And it's a huge inconvenience for her if that's true. So it's like he dragged her all the way back to Utah. They spent years and years going over this. She had to sit through her deposition. Her children had to sit through her deposition. And now she has to go through this 8-day trial. You know, she's probably pissed, and that's okay if she comes across on the stand that way, if that's how she really feels. So I think she did fine.
Yeah, I agree. So
what would you advise your client if they came to you with this case?
If my client was Sanderson, I would say it's probably not worth the effort. When I had my own firm and I did some plaintiff's work, I did mostly defense work, but I would take the occasional plaintiff's case if it was really good. And one of the things you have to do is really evaluate, am I willing to put myself at risk for this client, particularly if you're taking it on a contingency fee basis where you don't get paid unless they win? Is this client likable and believable to me? Is this case something I want to spend 2 or 3 years of my life on? And for me, a doctor in Mr. Sanderson's position versus Gwyneth Paltrow, I mean, I would probably not have wanted to take this case. That's just me personally.
Yeah.
What about you?
I think I agree with that. It depends on what evidence he had, but we saw what evidence was there, so probably not.
For me, it's when I'm taking a plaintiff's case, and most of the stuff that I did was, when I took a plaintiff's case, it was civil rights stuff. And one of the things I'd ask myself is, if I spend the time and money and effort on this, will I think it has been a worthwhile endeavor, even if we don't win? Is basically like, am I taking this case because it's the right thing to do? And it's particularly with the civil rights cases that I had, my answer was yes, because somebody has to stand up for those people. I was blessed with the ability to graduate from law school and pass bar exams, and I felt like that was something that I would feel good about, even if I couldn't end up winning for my client at the end. Now, this is the type of case where I wouldn't want to take it unless I was really, really confident that it was going to be profitable. And I think my evaluation of Sanderson would be, I don't think that a jury is going to respond to you, and you're fine, especially if I'd seen social media where he's traveling, cavorting around all over the world for years, but claiming that he has these major injuries. I think a jury is going to have a difficult time reconciling those two things.
Mm-hmm. Yeah, I think that's it. I don't have anything else to add.
No, I dove in. Yeah. Thank you guys for your excellent questions.
Yeah, great questions. It's always fun to watch a jury trial. You want to wrap us out?
Well, thanks, legal team, for listening. Make sure you check out our Instagram, our website, and our merch. We've got some really cute stuff. Also, thank you guys so much for your good reviews that you leave on iTunes. We really, really appreciate those. And it's a great way to support the podcast by leaving those nice reviews. If you have a correction or something that you would like us to change or work on, send that to our email so that we can read it and respond. And yeah, just thank you guys so much for your support.
Yeah. And if you want to find more ways to support the podcast and stay connected to us, check out the link in the episode description of this episode. And there you can find many other ways to connect with us, like our Patreon. Anyway, thank you for listening, everyone.
Bye, legal team.